Good morning. I am Advocate Manoj Wadekar. I am practicing on the trust and corporate sides in Pune courts as well as in Mumbai courts and Bombay High Court. The topic which I am going to discuss with you today is with respect to the general body meetings, managing committee meetings, the board of trustee meetings of the public trust, charitable organizations and NGOs which are in fact held because of the COVID-19 breakdown in today's circumstances. I have already sent a video on this subject. However, there was some audio problems which were faced by very many of the viewers, and therefore I am resending this video on the same subject, and you are please requested to consider this video, listen to this video carefully. This topic is very important because many of the trusts and NGOs are complaining that in the light of this COVID-19 breakdown, they are not in the position to hold the physical meetings of general body or the managing committee. Many of the trusts and NGOs have large number of members as members of the general body. Sometimes even the members of the managing committee or the board of trustees are also more than 50. In such eventuality, if the constitution or the trust deed of that particular trust or the charitable organization is not providing for holding a online meeting, then how to proceed further? Whether holding of the online meeting will be legal, whether it is possible to hold that in the absence of any directions. Unfortunately, the government has not issued any directions to the trust, thereby clarifying this position that whether during this period the general body meetings or the managing committee meetings should be held online or the bodies or the trust should wait for holding the general body meetings. The problem has become more serious since it is now about 7 to 8 months that the COVID-19 breakdown is continuing, and in fact there is a possibility of second wave of COVID-19, as a result of which again we are not aware as to how much period it will take further for the purpose when the physical meetings cannot be held. Many of the trusts are facing this problem that if their constitution is silent about holding of the online meeting, how to proceed further and how to hold the meetings. I am aware that the trust or the charitable organizations are required to take their decision jointly, because the Honorable High Court and Supreme Court has laid down in various rulings that the trust is not a living entity, and therefore whatever decisions it is going to take, the decisions are required to be taken jointly by virtue of holding a meeting of the board of trustees or a general body meeting and taking the decision which should be put in writing, and the records thereof should be maintained. Now, in this case, if the constitution is not providing an online meeting, then holding of the online meeting will be whether correct, and how to hold that meeting, how to maintain the records thereof is a big issue which has been faced by various trusts. In this respect, there is also a query by various trusts that under which provision of law such online meetings, if they want to take, if they desire to take, should be taken, and whether the Charity Commission will permit them. Our experience is that in some of the trusts where we have observed that when the online meetings have been taken for the purpose of holding the elections, and if the change report with respect to the election is filed, the opposite party may raise an objection that in the constitution there is no provision for holding the online meeting, and you have held the online meeting, the records are not maintained properly, there is no procedure or there is no provision as to how the records should be maintained, and therefore this meeting is irregular, this meeting is illegal, and therefore the change report based on the basis of the results in the online meeting cannot be accepted. In this case, the charity commissioners are also in dilemma. Charity commissioners also may be in dilemma that in such eventuality, what to do, how to go ahead. In the Office of Charity Commission also, it has been observed that there are various letters or representations sent to Charity Commissioner asking for the Charity Commissioner's guidance as to how should we go further. we can understand, we can appreciate this position that since this COVID-19 is a unique experience for all of us, the provision for the purpose of holding the online meetings were not introduced in the constitution, nor the lawmakers had anticipated this particular problem and had not made any provisions in the Maharashtra Public Trust Act or rules framed thereunder for the same. Therefore, a kind of a confusion and a dilemma is prevailing at present among the trustees and the charity commissioners also, and the authorities also rather, as to how to proceed further in such situation. The issue with respect to holding of these particular meetings can be addressed by invoking to the provisions, because even if the charity commission is the custodian of the trust, he is also bound by the provisions of Maharashtra Public Trust Act and the rules framed thereunder. As a result, if any such application comes in the form of a representation or a request, the charity commission may not be able to take the cognizance and give the relief or give the suggestions to the trust in the absence of specific guidelines or directives to the charity commission from the government of Maharashtra. In such eventuality, if the trust is able to make an application for the purpose of getting these guidelines or directions in the specific form, under the specific provision, then the charity commission definitely can pass such directions. For that purpose, we can invoke section 41A of Maharashtra Public Trust Act. It is our experience that if an application is forwarded to the charity commission for seeking directions or clarification in the present eve that there is no provision in their constitution for the purpose of holding the online meetings, the circular meetings cannot be held because by virtue of a circular meeting the elections or some important directions, important resolutions cannot be passed, then in that case the charity commission can give the clarification or directions under section 41A to that particular trust. Therefore, if the trust desires to hold the elections, I can understand, and we experience that during this last 7-8 months period, there are various important decisions pending to be taken either by the managing committee or to be approved by the general body, such as audit reports, the elections of the new body, because if the tenure is over of the body, then it is necessary to hold the further meeting of the general body for the purpose of electing the new managing committee or the governing body. However, in the present scenario, the such general body meeting cannot be held physically, and therefore for online meeting the permission of the charity commission is required to be obtained, and this is a question posed before many trusts as to how to proceed for that purpose. There are many times there are some important financial decisions which are required to be taken. What is happening today is that there are many trusts whose tenure of the managing committee or the board of trustees have expired. However, they are continuing to work. The effect of the same is that, as laid down in various rulings or various decided decisions of the Honorable High Court, that after the tenure of that particular body, a board of trustees or the managing committee or the governing body expires, that body becomes a caretaker body. The result of that is that such caretaker body is not supposed to take any policy decision or the financial decisions, cannot carry out the financial decisions or expenditure also without the permission of the charity commission. It is virtually not possible that for every financial decision or every policy decision you approach to the charity commission. Then, for the purpose of holding, the proper remedy in this case is to hold an election and elect a new managing body for the fresh tenure, which is necessary for the proper administration of the trust. Therefore, in such case, you can invoke section 41A of Maharashtra Public Trust Act and apply to the charity commission for the purpose of seeking directions for holding the general body, wherein you can take the important decisions such as any important policy decision, financial decision, or holding of the elections or approval to the audit reports, etc. So, my suggestion to all the trustees is that in case you are facing such problem about how to hold the meeting of the general body or the managing committee because of the large number of gathering which is possible of the members which is possible, which is in these cases, then you can hold the online meeting. However, for that purpose, a prior approval of the charity commissioner, prior directions or clarification of the charity commissioner can be obtained, and this can be obtained under section 41A of Maharashtra Public Trust Act. Thank you.